Alfred Henwood, aged 20, was riding a tram in Adelaide. The tram line had power poles holding electric wires which powered the tram. This particular type of tram was introduced in the 1920s, somewhat wider than previous trams, so the windows were closer to the power poles. The trams had signs warning passengers not to lean out of the tram. There was also a Tramways Authority bylaw imposing a £5 fine upon anybody leaning out of the tram. Alfred became motion sick and had to vomit. Without thinking, he leaned out of the tram to throw up, and his head struck a power pole. He was stunned, and before he could move, his head struck the next pole. He died a few minutes later. His parents sued the Tramways. The first instance judge found that Alfred's conduct was unlawful because it contravened the bylaw, and consequently found that he could not sue for negligence. On appeal, the High Court reversed this judgment. The leading judgment from Justices Dixon and McTiernan said, "We do not think that we ought to adopt, as part of the law of torts, a general principle that if the damage suffered by the plaintiff has been directly brought about by an act of his which is unlawful, he can never complain of a wrongful or negligent act or omission on the part of the defendant from which the damage otherwise flows as a reasonable and probable consequence." It appears to us that in every case the question must be whether it is part of the purpose of the law against which the plaintiff has offended to disentitle a person doing the prohibited act from complaining of the other party's neglect or default, without which his own act would not have resulted in injury. On this basis, they found that the bylaw prohibited people from leaning out of the tram, but that it did not prohibit people injured or killed by leaning out of the tram from suing in negligence. Indeed, the Tramways Authority had no power to make such a law. They did, however, say that in many cases, ignoring signs and bylaws like this would amount to contributory negligence. This case, which has been developed by many later cases, teaches us that illegal conduct does not automatically prevent a person from seeking damages if they are harmed by someone else's negligence.